Bolton. I do not have Attorney Lance in my waiting room. This is on Anchor Hydro versus Power REIT et al.
And Marengo and whatever. Okay, bring him in, and maybe Mr. Lance isn't going to appear on this.
Please unmute. Calling case 2023-3145 CB Anchor Hydro versus Power REIT et al. Today is Monday, May 13th, 2024 at 9:56 a.m.
Court will note the appearance of Mr. Gilbertson on behalf of the plaintiff, Mr. Bolton on behalf of defendant in this matter. We have Mr. Lance in it, but he's not here. Could you enlighten me is Mr. Lance intending to be here or doesn't need to because it's defendant Millennium's motion to set aside default and default judgment?
Good morning, Your Honor. For the record, Ian Bolton on behalf of Millennium Sustainable Ventures Corp. Your Honor, I do not believe Mr. Lance filed any response to the motion. I haven't spoken with Mr. Lance at all, and I don't believe he takes a position on this. My suspicion is he just didn't show up because he doesn't have anything to add. That being said, Your Honor, I didn't speak with him, so I'm not sure.
Okay, I'll just ask you, Mr. Bolton, you stated that the default and the default judgment were against a party that's name was incorrect. It's not your client's name. So if the judgment is not against your client, why do you need it set aside?
It's a really good question, Your Honor. I spoke with my client about this. I mean, the name on the complaint differs from the name on the default judgment, differs from the name on the proof of service, differs from my client's name. But they're all really close. And I assume once they obtain the default judgment, they will try to collect on the assets of my client.
Well, being really close, as you know, in the law, isn't accurate. So
I understand, Your Honor. The other option was just to let them have their default judgment against this made-up entity, and good luck trying to collect on it. But I didn't want to fight it later. I thought if we know what they're trying to get to, so we thought we'd get it set aside and deal with it now. But that being said, Your Honor, if the court is of the opinion that just let them have the default judgment against the made-up entity and then start over against my client one day, that's fine too.
Okay. Mr. Gilbertson, what's your thought?
Yes, thank you, Your Honor. Really the issue here is that the entities that have been named have all been identified by Mr. Bolton's CEO, his client, David Lesser, who's also the CEO of the other entities. So to the extent that he can't keep his entity's name straight and then now is using that as an umbrella to say, hey, you can't come after me because you had it misspelled or you had, also known as, and that's a sub-entity, not that, it's a complete shell game here. I think our response made that very clear.
Well, but the fact is you didn't get the default and the default judgment against the proper defendant. Is that accurate?
Well, the default judgment is against Millennium Sustainable Ventures Corp.
But the name is misspelled.
With one N, and that are multiple times back and forth in correspondence from Millennium Sustainable Ventures Corp. With two N's in it. And those are the emails back and forth.
Well, regardless, I'm talking about the judgment. I don't care about any emails or correspondence or anything of that nature. The fact is you have a default judgment against an entity that is not a party to the case.
Your Honor, I think the case law we provided on misnomer is clear, that misspelling an entity's name by a letter when they have actual knowledge of the case does not render a default judgment as invalid.
Well, what happens is, in this case, is the court obviously wants it to be accurate, correct. I'm not going to make those types of inferences in this and just assume that because somebody had misidentified or somebody got it right. I guess the only thing I can do, Mr. Bolton, is in this matter is the court is not going to set aside a default against a non-entity in this case. But if you feel better, the court would state simply that the plaintiff cannot execute against your client on this particular default judgment.
Okay. That works fine with me, Your Honor. I'll submit an order.
Okay. Thank you. You can submit under 7-day notice of entry. Thank you, gentlemen. You're free to go. Have a good day.
All right. You too.